And today I'm going to talk to you about how assets pass at death, how they transfer at death. Because one thing I learned in 30 plus years as an estate planning attorney is that this is a concept that many people don't fully grasp because we're never taught this in school. And so when people don't understand how various assets pass at death, many times their estate plans are not fully effectuated. Their intentions are not fully put into place because things pass differently than they thought they would. So let's talk a little bit about that. What I've realized is that most people believe that their last will and testament will govern everything they own and how it passes at death. And that is often not the case. Your will only governs those assets that you own in your separate name at the time of your death. In your own separate name, meaning there is no joint owner with a right of survivorship, there is no designated beneficiary, it's not owned in a trust, things like that. There's no pay on death beneficiary at all. So if I own my house in the name of Mary Hart and only my name, that will go through my will. But if I own that Mary Hart and Frank Hart, that's my husband, as joint tenants with the right of survivorship, then the moment I take my last breath, if Frank has survived me, he becomes the owner of the house by operation of law. So even if I said in my will that I'm going to leave my half of my house to the kids, that would not happen because it is not in my separate name. So my last will and testament doesn't govern what happens to my half of the house. It only will govern that house if it's owned in my separate name. So things that you own in your separate name, no joint owner with a right of survivorship, no beneficiary, not in a trust, those things will pass through your will if you have one, if you have a valid will. And if you do not have a will, then they will pass through the legislative will. What do I mean by that? The state legislatures have created a will for you. So you need to look at your state's law to see who would inherit from you any assets that you died with in your separate name if you did not have a will. We call that passing by the laws of intestacy. If you die with a will, you die testate. If you die without a will, you die intestate. So if you die without a will, the state legislature has tried to figure out what they think you would want, and that may or may not be what you actually want. But whether you die with a will or without a will, the only thing that passes by your will or by the legislative will are things in your separate name. So if you have an asset that has a joint owner, somebody else's name is on the title to that asset, if that is a joint owner with a right of survivorship, then when you die, that asset will pass to the survivor by operation of law. The moment you take your last breath, it's automatically owned by the survivor. There's nothing that needs to happen to make that transfer take place. Again, even if your will says something different, if there's a surviving joint owner with a right of survivorship, it doesn't matter what your will says because it will pass to the surviving joint owner by operation of law the moment you take your last breath. There's a little exception to that. Sometimes you can have somebody else's name, say on a deed to real property, but it might read Mary Hart and Frank Hart as tenants in common. Tenants in common is a form of joint ownership that does not pass to the surviving owner by right of survivorship. Whatever percentage you own as a tenant in common is treated as your own separate asset and will pass through your will. So look at your deeds if you have somebody else's name on it and find out, does it pass by right of survivorship or does it pass as a tenant in common through your will? So we've got assets that pass through your will. You've got assets that pass to a surviving joint owner. You might have assets that pass by virtue of a beneficiary designation. So say it's your IRA or life insurance policy. You filled out the form where you name your beneficiaries. That is essentially, by operation of law, it's a contract that says, these are my beneficiaries, these will inherit this asset when I die. If you have completed that beneficiary form and your beneficiary survives you, then your beneficiary will inherit that asset upon your last breath without anything else needing to be done except notifying the custodian of that asset. So if it's a life insurance company, for instance, you simply send the death certificate, or the beneficiary sends the death certificate to the life insurance company, and then they get the life insurance. But there's nothing that needs to be stated in your will for assets for which you have a beneficiary designation. You can have those sometimes with bank accounts or stock accounts. They're called pay on death accounts if they're set up that way. You have to ask the bank how your account is set up, or ask your stockbroker how that account is set up. So we have things in your separate name go through your will. Things with a joint owner with the right of survivorship go to the surviving joint owner. Things that are left to beneficiaries, either through a beneficiary designation form or through a pay on death account to named beneficiaries, will pass directly to those beneficiaries. If you own an asset in the name of a trust, meaning you don't really own it, the trust owns it, or the trustee of the trust owns it, those assets will pass according to the terms of the trust. Whatever the trust says is what happens. So they will not go through your will either. They will go through the terms of the trust. So it is very, very important to pay attention to how your assets are titled so that you know what type of document you need to make your asset pass the way you want it to pass. You cannot count on just using your will. So I usually recommend that people take a little spreadsheet and in one column write the name of the asset. In the next column, write the owners of the asset, and then how that asset is titled. Is it tenants in common? Is it joint with the right of survivorship? Is it a pay on death beneficiary? And then take a look, and then you'll figure out which document is needed to transfer the way you want it. So if it's something in your separate name, you would leave that through your will. If it's something to a surviving joint owner with the right of survivorship, there's nothing you need to do. It just passes automatically to that survivor. If it is a pay on death beneficiary type of asset, then you just need to make sure that your beneficiary designation is the way you want it, and it will pass automatically to the beneficiaries. If it's in a trust, then you just need to make sure the terms of the trust get to the right people in the right manner in which you choose through that trust instrument. And that's it, folks. That's basically how assets pass at death. It's critically important that you understand how that happens so that you can make sure your assets pass the right way.